So I wanted George to talk a little bit about the antitrust implications of different models of sharing. And in that regard, I asked him to take a look at some of the models that were laid out in the discussion framework and talk about them not simply from an antitrust perspective, but because George has been intimately involved in in advising as a practicing lawyer before he went into academia, so many different consortia in which data were shared, including inter-company consortia like the SNP consortium, also to talk about these issues from a policy perspective.
Great, Artie. Thanks very much. So let me frame this and give you 2 minutes worth of background on what we mean by antitrust law and competition law, because it comes up a lot, but doesn't often get explained that much. And competition law, antitrust law, is intended to protect the market, right? Not protect consumers, not necessarily protect competitors, but to protect the market and to make sure that the market has active competition, right? And so the antitrust law dislikes structures that do things like allow companies to coordinate their activities to raise prices, to allocate markets amongst themselves, and do other things that are going to reduce competition between each other, right? Otherwise, this is a thing that companies would love to do. They'd love to reduce competition. So sharing information, is one of the many possible things that companies can do when they get together that can reduce competition. Obviously, sharing information can also create efficiencies and be pro-competitive. And we're in a world of antitrust analysis where these types of arrangements are governed by what's called the rule of reason in the United States. You have to balance anti-competitive risks, anti-competitive harms against pro-competitive benefits, right? And there are admittedly going to be both. What are the pro-competitive benefits? I mean, this is, I think, the subject of the report and what people have been talking about for much of the day. There are definite efficiencies that can be created by sharing information, especially information about clinical trial design, processes, data models. Those will make every company's processes and operations more efficient. Obviously, there are benefits that arise from sharing toxicity and, safety-related issues with drugs. Again, it's a goal of the regulators in society to have as safe a product market as possible. So there are good pro-competitive benefits that are out there, but there are also potential anti-competitive benefits, and there's a lot of analysis of this in the healthcare industry and the pharmaceutical industry. Certainly, you can see there are plenty of cases around things like hospitals sharing information about salaries for their nurses, right? And you can understand why that would be bad, right? Because that means that they all will tacitly agree not to pay nurses more than X amount a year. And that is bad for the economy, and it's anti-competitive. Okay, so what kind of factors do the courts and do the regulatory agencies... Two mics?
I'm sorry, I didn't see that. Sorry.
What kind of factors are considered when we're analyzing an information sharing arrangement, right? Well, first is, what's the overall structure of the market? Is it highly concentrated? In the pharmaceuticals market, the answer is, yeah, that probably is a relatively concentrated market, at least in certain indications, and so that's not a good factor. Then, we look at whether it's individual company data or aggregated data. And if it's individual company data, well, that's also less good than aggregated data. Why? Because it's giving other market players information about what a company is doing, and that can help them structure their own behavior to compete with it. Okay. Current and future products versus past products. Again, it's worse to share information about your current and future products, but again, with clinical trials, that's of course what you want to do. So those are all, they fall on sort of the negative side of the ledger here. The real questions then we have to ask are, what are the public benefits that we're going to have by sharing particular types of data? A lot of the discussion today, and even on this panel, has treated data as sort of one and the same thing. But in an analysis like this, in a competition law analysis, you would try to look at the different types of data and understand whether there are benefits to certain types of data being shared or not. So we've talked a little bit about safety data, biomarkers, and those sorts of things that might be considered basic research tools. Again, pro-competitive benefits to sharing those, and don't give any particular company a leg up necessarily. When we talk about clinical trials data, we really need to think about what the data is and what are the pro-competitive benefits of sharing it. Beyond, animal trials, phase 1 toxicity, and basic safety information, you start to get into data that will reveal to you something about an individual company's likelihood of success with a product, its financial prospects, and its time to market with a new drug. And the risk, and I'm not saying this is realistic or not, in any particular case, but the risk is that competitors who receive the data will adjust their own behavior as a result of getting the data in a way that reduces competition. So, for example, Company A is developing an arthritis treatment. It's in clinical trials, and it shares those results with other companies in the market. If the results look very good, then other companies may shift away from from arthritis treatments or that category of arthritis treatments. If the results look bad, then they may alter their behavior by ratcheting up competition. And if they reduce their activity in the arthritis treatment area using this particular class of compounds, then 5 years later, you will not have 3 different, categories of arthritis treatment based on this class of compound to compete in the marketplace. You'll just have one, right? And you'll only have one because the one that had the lead to market, keyed the market in. They tipped their hand early to encourage others to get out of the market. And over the last century, there have been, many cases where this happened, not in the pharmaceutical industry, but in other much more pedestrian industries like gypsum wallboard, which is a far huger industry than you probably could imagine. But it has spawned many, many Supreme Court cases, lumber and all sorts of things, where competitors will adjust their behavior to get out of a market and tacitly allocate a market amongst themselves. Okay, you get arthritis, we'll get painkillers, because this is where our results are looking the best. Now, understandably, in these markets, there are announcements that are made to the public, and the FDA does reveal some of this information anyway, but to the extent that there's more information revealed earlier, that's something that the regulators will look at. Second category of risks and problems to think about is this dichotomy, and already talked about the 4 examples, between open access and closed company access, right, or group access, and both exist. Antitrust issues are going to be less, as you could probably imagine, with a structure that provides open access to anybody. With a closed group, where only, say, a certain number of pharmaceutical companies get access to each other's data, you have to ask why that is helpful for the marketplace in general. And not only that, you have to ask what harm those companies who are shut out are going to suffer from not being part of the group. You get into an area of the law called group boycott. And often small companies who are not invited to participate in the group are going to be able to bring an antitrust claim that says we were shut out of this group by the big guys because they all shared their data. They became much more efficient. They all knew that this class of drugs was highly toxic. We spent all of our venture capital money pursuing that class of drugs, and we never would have done it had we known that all the patients died, in the first trial. So there's that. There's another element of foreclosure also that is totally different. And this foreclosure risk in this theory comes about if we look at the data itself as the product. So, as already mentioned, one of the things that I worked on and helped to put together many years ago was the SNP consortium, which put out a SNP map of the human genome and, numerous markers, SNP markers that were discovered. The pharmaceutical companies each put in a large amount of money for the time, and the results were all released to the public, right? There was not sharing among the 12 members. all released to the public. This seemed fine from an antitrust perspective at first blush, until you realized that companies like Insight and Genset had announced that they were going to make a business of collecting and then licensing for profit SNP data to the pharmaceutical companies. And the SNP consortium was just going to collect all of this data and give it away for free. And the people who were paying to have this done were, of course, the potential customers of the biotech companies who were going to do that. That was the biggest risk, antitrust risk, with the SNP consortium. Not that the companies were going to get together and collude to split the market into different drug indications, but that there would be a foreclosure argument. And if there were small companies, small data-driven companies who perhaps had some agreements in place with pharmaceutical companies today, or were planning to, and then a plan came along that all this clinical trial data should just be released to the public anyway, then those companies' business plans would be disruptive. And that's when you have a potential antitrust claim by the smaller company to say, look, all of the big guys got together so that they didn't have to pay us to produce this data, which we were going to do. They really just did it to drive us out of business. Again, which the theory would be it's a harm to competition, and that is something that the antitrust laws try to protect against.
Thanks so much, George. So I had one quick question. So we have talked in the context of this session about the importance of having platforms that are as big as possible so that the average cost of doing each additional data analysis is lowered, because there's most of the cost it's spread out over many different data aggregators. So, but it sounds like if it's just big companies getting together and pooling their data, there might be some real concerns about that.
Well, again, I don't want to overstate the concerns or, set off alarm bells unnecessarily. Lots of these structures have gone on without serious antitrust challenge. Possibly because regulatory agencies themselves are involved. At the FDA, being involved in structuring one of these is a positive thing from an antitrust standpoint. But you're right. When large companies get together, companies that have what's called in antitrust parlance market power, and in the drug world, again, it's an oligopolistic market. There are just a few companies in each particular area that have a pretty significant amount of control. Yeah, you have to be sure that what's being proposed is not intended to pass information to competitors so that they can adjust their behavior to reduce competition that otherwise would be there had the sharing not happened. Unlike sort of the scientific ethos that talks about having people put the resources together as much as possible. The antitrust world is kind of topsy-turvy in that what it would like the best is to have 12 different companies out there competing in independent silos, each of them, creating their own method of doing something, and may the best one win. That is, theorized to produce the lowest prices for consumers. Vigorous competition drives prices down to their lowest level, and that may or may not always hold true. But there is not that much competition in the pharmaceutical world because of patents and because of the exclusivities that we've talked about, which is understood by the antitrust regulators, obviously. But, understood perhaps to some degree. But, but it is an interesting tension that exists as a result.
Are there questions for George? All right, I think we're at the close of our time, in addition to having our speakers all be done with their presentations. So let's thank our panel for incredible insights.